Hello and welcome to Liberty and Gun Rights Podcast. Today, Saturday, March 2nd, 2024. My name is James Moffett and I'll be your host. Today, I'll be sharing the first of a series of South Carolina gun law talks hosted by leading South Carolina gun law author and attorney Steve Shaw, along with attorney Robert Merting for free South Carolina gun law talks. These are going to be 30-minute mini seminars. Just South Carolina gun law, existing and proposed in Columbia and Washington. No sales pitches, no fluff, and no wasting of your time or ours. We're in a period of rapidly changing proposals to South Carolina and federal gun law. Further, there's eroding confidence in the information and advocacy provided by sources like SLED and the NRA. We are practicing South Carolina firearms attorneys who have handled cases like self-defense shootings, CWP denials, inherited NFA firearms, and restoration of civil rights. We have decades of experience representing gun owners, gun shops, and shooting ranges. We want the Second Amendment community of the upstate to have accurate existing law and reliable analysis of proposed laws and the record of candidates for political offices. Now, I'm going to say that this happened on February the 29th, which was just this last week. This in-person and online seminar has already been broadcast via GoToWebinar, and I spoke with Steve Shaw and asked him if it was okay for me to rebroadcast this to my listening audience, and he said yes, and so that's what I'm doing. Attorney Steve Shaw is the author of Shaw's 2023 South Carolina Gun Law, published annually. It's the authoritative book on self-defense, CWP, and possession of firearms in South Carolina. I'm going to show you on the website here in a second. However, I have one right here in my desk drawer. I don't know if you can see it or not. Let's see. Yep, I think you can. And this is the book on South Carolina gun law and self-defense law. Steve Shaw comes out with one of these frequently. Every time there's a new one out, I like to get my claws on one. So, having said that, Attorney Steve Shaw is the author of Shaw's 2023 South Carolina Gun Law, published annually. It's the authoritative book on self-defense, CWP, and possession of firearms in South Carolina. It's the only South Carolina gun law book in the libraries of the South Carolina Supreme Court, the University of South Carolina School of Law, and the South Carolina Criminal Justice Academy. Attorney General Alan Wilson writes on the back cover, "This is a comprehensive book that's a great resource for the average layperson or legal practitioner. I highly recommend it." For over 15 years in a row now, Shaw has produced the South Carolina Supreme Court Commission on CLE-approved South Carolina Gun Law Seminar for attorneys and judges throughout the state. Attorney Robert Merting is a leading firearms law lawyer located right here in the upstate. You can now get the same peer-reviewed content presented by Steve and Robert at the legal seminars. The talks will be presented in regularly scheduled learning modules that are recorded for anytime viewing through GoToWebinar. Topics will include self-defense in South Carolina, constitutional carry, guns in cars, churches, and on school grounds. Each session will have a generous open question and answers period. In other words, they host these South Carolina gun law seminars at different venues. And there's a law firm in the upstate, Geston Brady, I believe is the name of it, Geston Brady LLC, off of Pleasantburg Drive. And they were there, and the Geston Brady LLC law firm hosted it. Steve Shaw, Robert Merting, Roy Harmon from South Carolina Carry, and Randy Jones from South Carolina Carry. They are actually Zone 3 leaders for South Carolina Carry. There's no cost to you. The catch, we just ask you simply check out our sponsors, South Carolina Carry and Guest and Brady. South Carolina Carry is a nonprofit organization run by concerned South Carolina Second Amendment advocates. It is dedicated to promoting appreciation and respect for basic liberties guaranteed by the Bill of Rights. Guest and Brady LLC is a Greenville-based law firm that focuses on real estate and personal injury. Robert Merting, ESQ, is a Greenville-based firearms and general practice law firm. Okay, so as you can see over here on the screen, and I will try to make this larger so it's easier for you to view this. This is South Carolina Carry, the website. SouthCarolinaCarry.org. I'm not sure why it's taking so long to load. Here we go. Whoops. I don't want to do that. Visit site. So here's the website, SouthCarolinaCarry.org. And every time there's a South Carolina gun law seminar, we advertise it on our blog. So if you go to the blog and you go here and you can see Coffee, Donuts, and South Carolina gun law. We advertised it. I took this URL and I actually advertised it on all of the Second Amendment sites that I visit or am a member of, such as Palmetto Concealed Carry, Low Country Palmetto Concealed Carry, South Carolina Carry public Facebook group, which has over 3.5 thousand members, and other websites. But here's the advertisement. And in this advertisement, there's going to be a red button that says register for February 29th session. So, when the next gun law seminar is advertised, stay tuned to this website, SouthCarolinaCarry.org, and we will advertise it, and we will give you all of the particulars, and you can actually attend the online seminar for free. All you have to do is give them your name and your email address, and they will shoot you an email and tell you where to go, and online. And you can you can follow along on your smartphone, on your tablet, or your computer, whether it be a laptop or a desktop. But anyway, you can watch all of this online. After the fact, if you register for this, you will also be able to get the link for the webinar, and you can watch it after the fact. And so you can get that link from GoToWebinar through Steve Shaw. And I am also going to be, as a member of South Carolina Carry, I'm also going to be rebroadcasting the webinar every time they have one, so that I can hopefully give a lot more exposure to the great work that these attorneys are doing. If you want to know what's going on with South Carolina gun laws specifically, then you need to watch the South Carolina gun law seminars that's put on by Steve Shaw and Robert Merting. If that sounded like an advertisement, that's probably because it was. And no, I'm not getting paid to do it. I'm doing this as on a voluntary basis, just like my Liberty and Gun Rights podcast is free. So are my services as a volunteer to South Carolina Carry, and this is, I think, very powerful stuff. And our desire is to reach legal gun owners and citizens of South Carolina so that you will know what's going on in Columbia. All right? So here in a moment, we're going to transition over to the actual webinar, and you will be able to see or you can actually enjoy the webinar itself. All right, so please stand by.
Okay, we're going to try to start here. and we'll be talking a little loud because we're going to talk into the camera. Thank you all for coming. Hopefully, the people watching at home, we have at least 65 or 70 registered for this, so it's fantastic turnout for our quick little thing we just put together. But Robert and I, and along with Roy Harmon and Randy with South Carolina Carry, want to do this all the time. So have a regular meeting, and we're going to get some input from everybody, whether that be better in the evening or the mornings are fine, whatever. But we were just getting together, and one of the issues is that there's a lot of different information coming from a lot of different places, and I think with us doing this for the last 15 years, with the gun law book and the seminars that we put on for attorneys and judges, we are able to have whatever we're saying vetted by the people who actually practice this stuff in South Carolina. So I'm not trying to brag on anything, but I do think we can offer credible information, and that is what's needed here. Is somewhere some people can go to say, okay, these guys are at least giving us a straight talk of how South Carolina gun law works. Again, I'm doing this in conjunction with SC Carry, which is a state gun law advocacy and education organization. We would hope that you check them out because we plan to keep, they plan, and we plan to keep going as that organization, and it helps to give South Carolina its own place to go for information. The NRA is great national organization. I can argue that I think the cases that the big Supreme Court cases are the result of NRA. But I think when you get to the state level, it gets a little fuzzier.
South Carolina hasn't had a really good
Should you speak up?
organized group that's been pushing Second Amendment issues, whether that is, making sure bad laws don't pass or trying to push forward good laws and changes. We had an organization that has passed away in the last decade or so, and there's been a void there. And anytime you're going to try to get something through, whether it's Columbia or Washington or even Greenville County Council, that requires not just individual action, it requires organization. It requires people to have knowledge, to be on the same playbook, and that's what SC Carry wants to step in and do. And that is part of building this organization, building knowledge, and empowering the people that love the Second Amendment to go out there and protect it.
Exactly, Robert. So we plan to keep doing this. This is our first one, so if it's a little rough, hey, forgive us for that. The topic of the day right now going on in the legislature in Columbia is the constitutional carry bill. And from the feedback we've been getting, that's something people are interested in hearing, where that is and what it means, and maybe what can be done to make sure that is not going to be a worse situation than what we have right now. Getting into the education itself, in South Carolina, as far as handguns are concerned, and that's what most people are concerned about, carrying a handgun around for personal protection. We have in the law here a general handgun ban. So when you think of South Carolina gun law with respect to handguns, the blanket law is that it is against the law. It is a criminal act to walk around with a handgun. Then there's a list of all these exceptions to that, all kinds of exceptions we can get into. But the biggest exception for the general public being that you can carry you can get a concealed weapons permit from the state, from SLED, and that removes that criminal barrier from you in a lot of places. Not all. It's complicated. That's why we have to put together a book that's hundreds of pages. The idea with constitutional carry is to eliminate the requirement of having to go get a permit. So basically, back to what the Second Amendment promises, which is that our authority to carry firearms is not something the state gives us, but that we inherently have that, and that the Second Amendment is there to protect us from the state taking that away from us. So with that premise, we can start digging into what this constitutional carry law aims at doing.
Oh, the constitutional carry law, I would call it the permitless carry,
Permitless carry.
would turn 162320, and that's the general prohibition on possessing a handgun, would turn it on its head and say that you can possess a handgun, except for, and then list exceptions of places you cannot take. And these are the places that are the normal that we already have and we're familiar with. You can't carry one into a jail. You can't carry one into a judge's chamber or into a business meeting for a city or other municipal government. Otherwise already found in the CWP laws. A school, I heard that one stated. So what we would do with the permitless carry at its core is remove the general prohibition that we have in South Carolina and replace it with just some specific locations you cannot carry. That's a pretty clean theory, but in South Carolina, our bills and our laws are never terribly organized. They're kind of spread out in pieces everywhere. So there are a bunch of sections that we go into to remove special requirements for permits. And this might be the exception where you can, if you have a permit, carry onto a school ground, provided the gun remains in the car in certain places in the vehicle. So you'll see that language in there being removing the requirement for a permit, allowing anybody can legally possess a gun. And you'll see that go on for state parks, for parking on Capitol grounds, and many other places where we have put in an ad hoc prohibition on possession of a gun, and then put in a similar ad hoc admission for CWP carry. And what I should say kind of at the beginning of this, because there's a misinformation out there, this law does not change who can possess guns as far as allowing greater possession. There are some limitations where it would tighten that, and we'll talk about those. But this is not a law that is guns for everyone, even if they can't legally own them. And that has been a communication or misinformation provided by those who oppose the permitless carry, saying that, oh, you're going to allow anybody to have a gun. No, the statute merely says if you can already legally own a gun, then you can legally own it anywhere, not just in certain locations as we now allow. So let's juxtapose that with the extra burdens that are going to be placed in the bill on those who are prohibited persons. I suspect most of us are familiar with the idea of prohibited persons, generally called a felon in possession, which actually is not dependent upon felony status. It's dependent upon being convicted of a crime with a certain length of possible punishment. And the word felony is not actually anywhere in that statute at the federal level. At the state level, we do use the word felony when we have our prohibitions. And our prohibitions are much narrower in nature than the federal. The federal prohibitions have tried to say every felony with maybe some minor exceptions for business crimes. What our state has done and come back and said, wait a minute, we're going to go violent felonies. If you have a non-violent felony, then we're not going to concern ourselves with whether or not that is a prohibiting factor. If you have a high-level misdemeanor, we're not going to concern ourselves with whether or not that's a prohibiting factor. Only violent felonies. This law, as passed by both the House and the Senate, would change that. And what this law proposes to do is come in and remove the language about violent felonies as prohibitors and replace it with prohibitors based off of a conviction for a crime that carries more than 1 year imprisonment. Now that's going to catch even some misdemeanors. It's going to catch pretty much all your non-violent felonies. And violent felonies in this state are actually defined and explicitly listed in a statute. So even things that you and I might think of as violent aren't necessarily violent until they rise to a certain level. But a good example might be a possession of a drug with intent to distribute. It's a felony, but it's not a violent felony. Trafficking, the next level up, is the violent felony. So we would increase the people that are prohibited, and then we dial that back in the footnotes, if you will, because now a crime punishable by more than 1 year is excluding misdemeanors punishable by more than or less than 5 years. And then it excludes crimes that are business regulatory in nature. What we wind up doing is kind of following the federal law in the sense that we use a name, crimes punishable by more than 1 year, the feds use that same name. And then just like the feds do, we define it to mean something completely different than what it says, crimes punishable by more than 1 year, because we exempt a whole bunch of things out that are crimes punishable by more than 1 year. To make it worse, we use the exact same term the Fed does, and then we make a completely different definition than the Fed has. So if you say, what's a crime punishable by more than 1 year? If this bill passes, the question next following is going to be, whose definition? Because it's going to be different. It doesn't mean what it says in neither case. It means something different, and it will mean that based upon whether we're talking state definition or federal definition. So I would be a critic of the bill saying that we ought to use a term that is not oxymoronic the moment we define it. We ought to use a term that we can define a little bit cleaner and clearer, which makes people look at the meaning versus assuming a wrong meaning.
Any questions? You can always ask questions.
We encourage interruptions.
Yeah, we encourage interruptions.
I have a question, and nobody down there can answer this.
And we'll repeat it after you say it. So,
Thank you, Steve. I will.
yes.
Why this violent thing? That's what the governor wants. That's what this whole. That's what he wants to sign. Why did they not come up with a separate bill, just not in part of this, and figure out between the federal felony and South Carolina, get that figured out instead of tying it in with this? And this law is, like I said, ridiculous. It goes on. I mean, it's like the.
So the question is, our governor, Henry McMaster, has requested harsher punishments for what we would colloquially call felons in possession. What we just talked about, those people have a crime conviction punished by more than 1 year. He has requested harsher punishment for them. He's requested more prohibited persons. And the question is, why was that not a separate bill where we would have permitless carry and we'd have that bill tracking simultaneously? And I would answer in one word, politics. In more detail, I would say that I don't think that the governor's bill would have any chance whatsoever at passing. There are a lot of very conservatives out there who take the view that if the man is dangerous, don't release him on the street. And if you're safe enough to release him on the street, give him his natural rights back. And those conservatives, I'm in that camp, would not ask for, tolerate, or support in any way, shape, or form pure gun control. And that's what the governor is asking for, is pure gun control. So in an attempt to try to get that through, and hopefully that it would carry constitutional carry with it, we tried to take two strange bedfellows and put them together. Persons that want more gun control and persons that want more gun rights. And what we wind up with is a bill that really makes nobody happy. And I think that is part of the issue and problem. The Senate has compounded that. The Senate didn't even like that compromise. And the Senate has added in a series of restrictions and odd amendments that some of them are baffling. I think the Senate was tone deaf when they went into the special exception to the rules. And we got a special exception to the rules that says if you are a permit holder and you also happen to be one of these now 12, 13 people, we're going to extend it to 16 different people. If you're one of these 16 different classes of people, you get to carry your gun anywhere, regardless of what the law says. You get to take it anywhere you want. Do you want to guess who the Senate added that list of 16 special groups of people?
Themselves.
Yes.
Carpooling. He said he was going to put it addendum to it on the floor. He said, I'm going to add it where we can carry it here.
That's exactly what the Senate did. They added themselves. They patted themselves on the back, and they said all animals are created equal, but some animals are more equal than others. And they were counting themselves among that group. I take exception with that. If the law is going to apply, it should apply equally. And if we're going to allow a person to carry anywhere in the state, we ought to allow every person to carry anywhere in the state. Now, if we're going to have a true gun-free zone, which I think is completely unable to really operate and function, then let's make it a true gun-free zone. We'll see the ridiculousness of that fairly quick. That's one thing the Senate did. The Senate also added a crime that if you are not a CWP holder and you carry a concealable weapon and commit another crime, then they'll punish you for committing that crime without a permit, and they'll punish you with a 3-year, I think it's a misdemeanor, conviction. So I'm guessing that they are now saying that we can permit crime, and as long as we have a permit, it's okay and it's not a crime. The real trouble I have with that is the law seems to accomplish nothing other than making a mess for your gun rights. Because it says you can punishment not to exceed 3 years, and it cannot be longer than the time period of the underlying offense. So illegally carrying a firearm in one of the places you're not supposed to may only be a 1-year misdemeanor. So now I've got a 1-year misdemeanor. I've got this additional crime that I've been hit with that cannot exceed 3 years, but cannot exceed the 1 year. But on its face, it cannot exceed 3 years. And that's very critical because remember that I mentioned earlier, you're prohibited from possessing a gun if you're convicted by a crime that can carry more than 1 year. That's federal prohibition. Well, that federal prohibition actually is for misdemeanors, state and DC municipal. For misdemeanors, that's a crime punishable by more than 2 years. So punishable by more than 3, whether it's a misdemeanor or felony, is going to trigger that. But is it going to trigger it when the underlying offense is only by 1 year and the statutory language says you couldn't exceed that underlying offense? It's a question I've not seen answered. I've not seen a statute worded that poorly. So new accomplishment by Columbia. So I don't know if that's conviction would trigger a federal prohibition. And I have a real concern that we're passing new gun laws that if you happen to just peacefully violate because you carry in the wrong spot, that you're now going to be a prohibited person forevermore. I take real exception with that. And unfortunately, somebody is going to spend a lot of money trying to figure out exactly what that statute means and how to interpret it with federal law. And that's one other issue that I've taken or would take with what the Senate has actually sent over to the House, which, by the way, the House has rejected.
And unless there's a question, I was going to ask you we had talked about the position and the history of the bill. Can you go over that about?
I think this is a good time to go back into where we are.
Yeah, where we are.
Certainly we're talking about the details. We jumped into it. So currently there is I'm going to do this backwards. We have a committee between the House and the Senate that are formed. It is actually chaired by Senator Brad Hutto. So this committee consists of 2 House Republicans, Micah
McCaskey.
Bobby Cox, and Justin Bamberg. And then in the Senate, Shane Massey, Brad Hutto, and Shane Martin. So that's 2 Republican senators, 1 Democrat senator, 2 Republican House members, 1 Democrat House member, which is about right. Republicans have about 2/3 in each one of those chambers. And those 6...
So Massey's just a Republican in name only.
I hear you, and the criticism of Massey is Republican in name only.
He's been fighting all the 2A gun stuff.
We're going to get to this. So we send nominally 4 Republicans and 2 Democrats, a very clear majority of Republicans, and they promptly come together and appoint one of the 2 Democrats to be chairman of the committee. I think that says a lot about where some of those, quote, 4 Republicans actually sit. We have conservatives, true conservatives up there. We have establishment Republicans that I think see a lot more in common with the Democrats than we have the Democrats up there. And that group has been very happy and put a staunch opponent of this bill on top of trying to come and reach some conclusion, some compromise between the House version and the Senate version. I expect there won't be a compromise reached, or if it is reached, it'll be rejected. So before we got to the appointing of the House members, appointing of the Senate members, the Senate would not concur in the House amendments. Prior to that, the House received the Senate amendments, looked at them, and they did about what I did with them. They threw them in the trash can and put their own bill right back in, and then sent over to the Senate. And before that, the Senate had taken the House version and added a whole bunch of things to it, like the I'm special too, include me, and I can carry anywhere. And we're really mean it. We're going to punish you by more. And, let's compete with concealed carry permit trainers, and we're going to make SLED offer free concealed carry classes until market saturation, and a bunch of other stuff, all, I think, designed to try and kill the bill, which may have been the most successful thing the Senate has done that week. So that's, without going further back, that's where we get to here. Is we had a bill come out of the House. The Senate added a bunch of stuff to it that did not further the underlying spirit of the bill, but really hampered it. The House just fully rejected that. The Senate, without even taking a vote, just by unanimous consent, rejected the House's rejection. And then we formed the committee, and the committee is going to meet sometime. And if this is not all done by May of this year, or when the Senate and the House adjourn, then the bill dies and we start over next year.
And before I do that, Roy, I wanted to get the point across that it is a group like SC Carry. It's folks that care about South Carolina gun law rights and your right to carry. That's why we're doing this. And somebody has to keep an eye on these guys. And these bills that start getting watered down and made ridiculous and are self-serving to those guys in Columbia. I think everybody in this room has just kind of had it with that. And I guess my commitment to you is that we want to let you know that we're keeping an eye on this stuff. We're listening to the people who watch it, and we're trying to do something about it.
And this is a group effort. It takes help.
Yeah.
Without
We need your
without
help.
you all here in the room,
Yeah.
without you all listening, if you're not there talking to your legislators, if you're not telling them what they're doing right and what they're doing wrong, they're going to do it to you. And they're not going to care one bit. That almost happened here. The Senate rejected one of these bills in a previous session. They caught so much flack that they've had to bring this back up to help a couple of the members that voted no. They didn't think it would pass, but it did with all these amendments. And the House heard so much about the Senate amendments, the House just had to reject them. If the House hadn't been hearing that pushback from the South Carolinians, we would have the Senate version as law by now. And you and I would be talking about all the different ways which you could be made a prohibited persons and all the extra punishments that were going to fall on people that made mistakes. So people like you being involved make a difference. And that's what we want to organize.
During campaign season, all of the politicians say they're pro-Second Amendment. So at this moment, looking at what happened in Columbia, when it comes to the Senate, was there any senator that voted in a way that didn't enable this non-concurrence and this amendment process to go forward? Are there any senator that has a clean record, not just voting against the amendments, but also voting against the non-concurrence, which sits this thing into committee, which now leaves us where we are?
So the question is there any senator with a clean record voting against the non-concurrence, and not just amendments, but the non-concurrence that sent this into committee? And unfortunately, to answer the question, I believe that the non-concurrence was unanimous consent, that it was proposed to be sent in, and no senator actually stood up and objected to that, which is very unfortunate. I like to think there's some senator that did object to that, but none stood on the record to speak to it. And that goes to maybe the willingness of a senator to die on this hill, or to make his point very clear that I'm going to push you to a vote. And sometimes that's the best we can ask for. We may know we're not going to pass something this year, but to force those senators and representatives to put themselves on the record, make a vote so we can actually see how you voted, allows us to compare your actual record to what you're going to tell me during campaign season. I don't want to hear talk. I want to see results. And so I want to see voting records. That's how we can tell you where they really stand when the rubber meets the road. I think we're nearing our time, Steve.
Yeah, Robert has to leave. Both of us are working guys, so I know you've got to go to an appointment. Well, thank you, Robert. Is there any more questions in here? In the future, we're trying to be mindful of your time too. Everybody's got to go to work and different things. So these will be brief enough, but the main point is always feel free to email Robert or myself. I will make sure you have Robert's email. Robert does a ton of things with firearms law, everything from NFA, all getting through the minefield of NFA right now, the different changes. He does things with gun shops. He does things for people who have been denied CWPs, everything to that to a self-defense shooting. So I want to say thank you, Robert.
Steve, thank you for that. Steve puts together seminars, so he's got a lot of knowledge, a lot of contacts on this. I encourage you, give us some feedback. Tell us what you like. Tell us what you want to see. Tell us what time of day, what day of the week works for you. I want to make this a regular monthly occurrence where we actually can build a good group that knows what's going on, that can help us move Second Amendment legislation through South Carolina Carry. We think that's the organization that will help do that. And so we're asking you all to help us form that Greenville group.
And it's important to note too, it's not their first rodeo with this stuff. How long you guys been around for
We've been around quite a long time. We were in the fight when we added Georgia as one of the states that we could carry in. We were in the fight when we had open carry come through. So we have had some victories. We have been there. We have some allies. We have some people that aren't so much of allies. We got some people that dislike us. But if everybody likes you, you're not being effective.
Also, the signage issues, we frequently get involved in those.
Oh,
Yes, the local sign, where the counties, one of your board members was successful in, I think it's Charleston County or.
we had a county park in Charleston County, had prohibited signs out there. We were able to work with the Attorney General to determine that that is not legal, by his opinion. We had one of our board members individually brought a suit against the county, and then we activated local representatives down there, leaned on the governor, who helped us get those signs removed. So the county parks in Charleston now allow the carry of firearms, much to their dismay.
If I could add something selfishly, speaking of bugging those people down in Columbia, I'm probably on trespass notice by now. I met with Jason Elliott. He put in House Bill 5013. I carry, I got a CWP, I'm retired law enforcement. We carry under a Senate authority, I guess, so to speak, that our sheriff or chief or whoever signs off, FBI. Same thing. He put in one, and basically what it does is alleviate signs and private property for qualified law enforcement. Now, we have to qualify every year. I just qualified on Valentine's Day. They do a background, they keep serial numbers on your guns and all that. There's also a Senate bill, 170, that's been sitting in committee since 23. Now Jason put his in February 6th, and I met with him for an hour and a half, and he was really very open-minded. So I don't understand, and the reason I got looking at it was this laundry list of people with CWPs, workers' comp commissioners. I don't know if they've ever put anybody in prison. I have. I've had encounters at a restaurant with a guy put in prison. Thank God it went okay, but it could have gone the other way. And what about if the Bojangles we were at would say, oh, you can't carry in here. So we're trying, if you can bug your people, if you've got any law enforcement people, to let them know this bill's out there. And I totally agree with CWP, the signage, as we've seen in other parts of the country, New York, everything.
Let me just make sure, the webinar people can't hear you. So
Yeah.
if we can, are you saying you're for that to create
yeah.
a special for law?
Yeah.
So you're saying law enforcement people, retired,
Yeah.
should have a special right to not even inform or not have to have permission of the business owner to carry just by the fact that it's retired law enforcement.
Right.
I'm completely against that. That was
Yeah.
Jason Elliott's bill that I think is horrible, but I wanted to make sure, why do you think that's a good idea? As opposed to anybody else being able to do
Oh, I
that.
think everybody.
Okay, you think, okay,
I'm not saying we're special.
gotcha.
But what got me on this was, as he mentioned before, judges, which I'm fine with that, solicitors, they do, but I started looking at this and I never looked at it. I said, everybody but their yard man gets to care because they're, as you said, they're in a different group. And then when the senators add theirs, I'm like, we've done this for a living. We have to qualify every year, and they go to an 8-hour course, and all of a sudden they're the FBI SWAT team or something. They got special. I think it should be blanket for everybody.
Just okay.
Yeah, I'm not saying we're special. It's just kind of ridiculous that you look at that law, and I got to look and say, well, we have to go through a lot more than the 8-hour thing. So,
4 hours now.
Yeah. So
No, I understand. I think that's, creating these special people, and I know I'm a constable myself,
Yeah.
so I mean, basically we're talking about you do a handgun, like a shooting qualification,
Right.
but it's not about Fourth Amendment updates. It's not about probable cause updates, all those things, that to me is much more complicated when you're going on somebody's private property as a retired law enforcement officer. That's, to me, it's a little crazy. I think I don't think the public's for that. That's I guess what I'm saying. But I understand the initial thinking. I think you got to go.
I'm about to say thank you all to those who attended this webinar, and thank you all to those who attended in person. We appreciate it.
We look forward to next week. Thank you.
Yeah, thank you guys very much for coming out. I'll shut this. Well,
As a quick room consensus, when would y'all like to meet? If y'all are willing to meet, want to meet on a monthly basis, what time of day, what days of the week?
Yeah, this is the time.